is Keith Bray. I'm the reporter appointed by Scottish ministers to consider the application for the Newlands Hill wind farm. That's under Section 36 of the Electricity Act. As many of you will be aware, it's ministers to decide whether or not applications are approved, and that is after consideration of a report of the inquiry. The purpose of the meeting today is to discuss how the inquiry can be conducted in the most efficient manner. There won't be any discussion on the merits of the application. As is quite clear, it's a virtual meeting, and Connor, who I think you've probably all met this morning, is listening in and will help if there are any technical difficulties. You probably need to stay on mute just now, but if you need to speak at any point, come off mute. If you want to speak, you can also use your electronic hand, and I should be able to see that. If I'm not, then please just interrupt if I have passed by and not allowed you to come in. The ideal situation would be the main speaker for each party to keep their camera on. If you have a number of people representing, it would be useful if just one person kept their camera on and did most of the speaking. The meeting is being recorded. It's broadcast live. In due course, that recording will be available to view on our website. So by taking part in the meeting, you are consenting to be filmed, and that may be used and stored for the purposes of webcasting and training and keeping a historical record. And it obviously will be available to other members of the public. So hopefully you're all content with that. I haven't planned for a formal break in the agenda. As you'll see, we can review this as we go on, but I probably would like to ask for a short break between items 7 and 8. That's hopefully if we get to those items and we'll be discussing dates for procedures, then I will probably ask for a little break at that point. So that's just a heads up there. Hopefully we'll be done by 1 o'clock today, but we'll just take as long as we need to as we go through the agenda. And talking of the agenda, I'm hopeful that everyone has a copy of the agenda in front of you, either in paper form or electronically. If you don't have an agenda, then hopefully you can follow me, or you could raise your hands and we might be able to get one to you. But I can't see any hands up. You will all probably have that agenda in front of you. Okay, that's my introduction. Item 2 is where I ask others to introduce themselves. First of all, I would like the applicant to introduce themselves today. So over to the applicant.
Thanks, sir. Good morning. My name is Marcus Trinick. I'm a solicitor, King's Counsel, instructed by Fraser Gillis and Wright Johnson Mackenzie, whose face appears on screen now. Also accompanying me at this pre-examination meeting are James Gray and Ruth Luckins of Belltown Power. Thank you, sir.
Thank you, Mr. Trinick. And we usually go to the council now. If we could ask the council to introduce themselves.
Sir, I'm Alistair Burnett, King's Counsel, instructed on behalf of East Lothian Council by David Forrester of Morton Fraser McRoberts, and I also have in the room Carlo Grilli from the Council's legal team and Graham Marsden from the Council's planning team.
Thank you, Mr. Burnett, for that. We do have a number of people on the call, and I'm not necessarily going to go through everyone and force everyone to introduce themselves, because that might eat in. But is there anyone from the community councils here, either East Lammermuir Community Council or Dunpender Community Council?
Yes, but my name is Chris Bruce. I'm the chair of East Lammermuir Community Council.
Thank you very much, Mr. Bruce.
Yes, I'm Linda Shaw-Stewart, and I'm representing Dunpender Community Council.
That's excellent. When you are speaking, if you can pop your video on, that's useful as well. You don't need to keep the video off all the time. Are there any other groups that are represented here that would like to introduce themselves? I know that a number of estates are represented by Mr. Finlay, I think. So, Mr. Finlay, could you introduce?
Yes, good morning, sir. My name is James Finlay, King's Counsel. I'm instructed by Ian Kelly, and who's also attending the call this morning, and I appear on behalf of Northumberland Hopes and Mayshiel Estates.
Thank you, Mr. Finlay. Are there anyone else? Mr. Ford, Dr. Ford.
Good morning, sir. I'm Dr. Christopher Ford. I'm a chartered town planner and specialist in energy systems. I am representing Lammermuir SOS today.
Do I see any other hands up from groups that are keen to introduce themselves? I don't think so. Just because you haven't introduced yourself, that doesn't mean to say you cannot speak during proceedings, but it'll just allow us to move on. I'm assuming that the others are those who made representations as individuals. And perhaps Stuart from Community Council, if you could take your hand down just now, unless you've got something to say.
Sorry.
That's fine. That's great. I'm sure there'll be lots of that technical stuff as we move on. I don't think Scotways could participate today, so I wasn't anticipating Scotways to be here. Anyone who isn't in attendance today can watch, will be able to watch this back once it is on our website. So for those participants, people who have expressed a view to be involved in the inquiry process in some way, they will be able to watch it back. Now, before I go on to item 3, there has been a little bit of correspondence between parties just in advance of the PEM, which is not unusual. Just for all parties to know that the applicant has written to the council and Mr. Kelly on potential dates for oral process, but we'll come on to that later on the agenda. So there has been a little bit of discussion there. The applicant has also written to the council on a number of topics to try and narrow, if you like, the scope of the inquiry and to reach agreement on certain matters. Now, later on, I think I'll ask the applicant to talk us through that later, but that will be later on the agenda. But I'm just flagging it up now because there is potential crossover between that letter and whatever procedures we might agree later on. So we'll come back to the letter later on in the meeting, unless the applicant wanted to flag up anything in particular with the letter that was sent on the 4th of March. Are you happy to come back to that once we go on to procedures, Mr. Trinick?
Absolutely, sir.
Thank you for that. We'll probably talk about that when we're talking about further written submissions later on. Okay, item 3, which is a recent court judgment, which some will be becoming familiar with now. And I've noticed that the council has raised this particular matter in its position statement. So the ratio judgment is a recent court of session decision. It concerns whether a wind farm and associated grid connection properly constitute a single project requiring EIA. The Scottish Government is still considering the implications of that judgment and the next steps. However, I would plan to seek further written submissions from parties on the judgment and the implications for this case and the issues that it raises. That would be a matter that would be set out in the note of the meeting. And before I take the applicant in, what I would propose is allow the applicant a period of time to answer some questions that I can put down in writing to set out their position, and allow other parties, including the council, the opportunity to comment on that, and allowing the applicant, if you like, the final word after that in terms of its position. I think that's all that I propose at the moment, given the position that the Scottish Government haven't come to a conclusion on the implications of that judgment so far. If we can turn to the applicant, what I've set out there in terms of further written submissions, are you content with that approach?
Go first. Yes, I'm entirely content with that. If there may well be a need for written submissions, but I think it might short circuit matters, as I indicated, the applicant's practical response to the WIN-210 decision for the purposes of this inquiry. Noting that the judgment remains subject to a possible challenge until the 17th of March. What we intend to do is to provide a cumulative EIA of the wind farm with its grid connection. I'm not going to go into detail now of exactly what's going to be produced, but I can say that the grid connection for this project received a positive screening opinion. SVT submitted a report and got a screening opinion in August 25. And an EIA scoping opinion for the grid connection was issued to SVT in February 26. That opinion is on the ECU site if anyone wanted to see it. And what the applicant intends, building on that scoping opinion, is to undertake an EIA of the grid connection and put it into the inquiry as AI. And we ask, sir, that you require this information for the purposes of the inquiry so as to avoid the need to advertise the information. So that is a practical response. I can say to Mr. Finlay, indeed, he and I did have a conversation about this yesterday. This is not a case where the applicants will be making a claim that we have two projects for EIA purposes, a single project for EIA purposes. That is the approach which we are taking in this case. I hope that makes things easier in some ways for people to respond, and I hope that helps. That AI will be ready for submission by the 15th of May. If I can help with anything, sir, very happy to do so.
Thank you, Mr. Trinick, for that. That is useful that you've set out that. It may mean that I seek to clarify that through written submissions in terms of your approach, but that and will likely lessen my questions to you, because I think you've answered some there. So the scope of any written submissions, I think, will be reduced, but I think I would ask a couple of questions just so that you clarify that. Given that the timescale is May, we could get those an exchange of written submissions done in advance of that. That's my initial response to what you've said, but I would ask the council if they've got any thoughts on what you've heard, both from myself and from Mr. Trinick.
Thank you, sir. We welcome the opportunity to have an exchange of written submissions, but given the applicant's practical acceptance that they will have to bring forward further information for you to consider, we'll need to wait to see what the information when it comes in, but we'll take stock at that stage. But I suspect it may have an effect on the timetable and the ability to set a timetable today, but we will just have to wait and see. I think the principle may not be an issue if that is the applicant's proposed form of moving forward. So it may be a short exchange of some written submissions, but we'll have to see what is then produced thereafter.
Mr. Finlay, you have your hand up.
Yes, sir. Thank you. Mr. Trinick mentioned that he and I had discussions yesterday. My understanding is, as he has confirmed this morning, he accepts you should treat this single project, and that is indeed a sensible in our submission way forward. And if that is the case, we're unlikely to have much to add by way of any written submissions. I echo Mr. Burnett's point that that may well have implications as to timetable, which we can come on to in due course. But the scoping opinion to which Mr. Trinick referred makes it clear there are quite a number of matters that will need to be, or investigations that will need to be done. What is being proposed is an overhead line, so there'll be landscape and visual implications, and there will also be the other potential biodiversity, peat, soil implications that will need to be investigated, and they're all set out in the scoping opinion. Subject to placing a marker as to timetable and the need for all relevant parties to react to that. And I should say that one of my clients is the owner of the land through which the overhead line will run, so it particularly concerns one of my clients. Subject to that, that is an acceptable way of dealing with the racial judgment.
Mr. Ford, Dr. Ford.
Just to say, I welcome the applicant's view that this is to be treated as a single project. I think that's appropriate in the light of the judgment, and in a sense is almost inevitable, actually. And then we kind of come on to the matter of timing. And obviously, if the applicant is intending to get this information by, within 2 or 3 months, that will be helpful, or they'll probably slow down the inquiry process. The other convenient thing is that gets past the potential appeal date, although whilst I don't think that's very likely, that the fact is that covers that procedural point. Certainly happy to deal with any written responses, but on the basis that the grid connection will be treated within the EIA as a single project, I think that puts this issue beyond doubt in a sense. And I certainly welcome the applicant's acceptance of that. Thank you.
Mr. Trinick.
So, no, I can't put my hand down, so please ignore the hand.
That's fine. Well, is there any other parties or any other people wishing to contribute to this discussion? Because I am getting a sense that having written submissions at the moment, in light of what the applicant has said, may not be required. However, we have the applicant indicating that given the timing of this and we're in the inquiry, that I should be requesting that information for the purposes of this inquiry, which appears in the first instance to make sense. I would ask parties' views that all participants in the inquiry get the opportunity to comment on that, so that there would be further written submissions on the back of information that was submitted, so that all parties that opted into this inquiry would be given the opportunity to comment on the additional information that was submitted by the applicant, and then the applicant given the opportunity to respond to any submissions that have been made. Mr. Trinick, does that suggestion sit well with you?
Yes, sir, it does.
And Are all parties generally content with that approach? That it's likely that the request for the purpose of the inquiry will be contained in the meeting note, and set out what we expect in terms of procedure once the information is provided. Okay. No other parties need to chip in at that point. Okay, that's useful. Thank you to the applicant for giving that some thought ahead of today. That's been very useful. Item 4 is just a general discussion about the framework, if you like, for these sort of inquiries. You may all be very familiar with inquiries for Section 36 applications for wind farms. You may not. Historically, it's the code of practice for handling inquiries that provided a link for there. That is what we've used as a kind of framework for deciding procedures. Generally speaking, it allows for fairly flexible procedures, generally agreed through the minute of this meeting. You might also be aware of a new piece of legislation, Planning Infrastructure Act 2025, that introduces new measures on how Section 36 applications and cases will be managed. That came into effect in the middle of February. There has been a letter issued by Mr. McKee, the Minister, and my reading of that is that those new measures, if you like, don't impact this case because the Council's objection was made sometime before that. I just wanted to clarify that all the parties are content that we're working, in a sense, under the old rules and not under the Planning Infrastructure Act 2020. So we have a thumbs up from Mr. Trinick and we have thumbs up from everyone else, which is a lot quicker than speaking. So that's great. Thank you very much for that. I'm just going to check my other screen to see if there's anyone else with hands up. So no, there doesn't seem to be. You can see from the agenda that I've already set out how I think the case should proceed, if you like, under the code, and we'll discuss that soon. And we might be talking about different procedures that people haven't heard of before. I can offer the opportunity just now to just quickly run through what further written submissions are, what hearing sessions are, or what inquiry sessions are. But if you're all familiar with those terms and have been involved in inquiries before, then I need not do that. But if anyone would like me to explain before we start to talk about procedures what's involved, then I can do that. So I'll just look around the room to see if there are any hands or anyone requiring those procedures to be explained. It doesn't look like it. I'm not seeing any faces appearing or hands. So you're probably all familiar then with further written submissions, hearings and inquiries and site inspections and such like. So thank you for saving me a few paragraphs.
Sorry, sir, I had to put my hand this way. I'm familiar with that. I'm just wondering about item 5 on the agenda before we go on to procedures.
Oh yes, I was going to come to that. Yeah. That's on my list. I haven't scrolled down that far. Yeah, Mr. Trinick.
Sure.
I was just making those comments in reference to the code of conduct. The final note I have here under this agenda item is to encourage all participants to look at the DPA guidance notes 23 and 29. They deal with managing an inquiry process and also, importantly, how we manage documentation. And that's a relatively new guidance note 29, how we deal with documentation. And we'll come on to that later on. I'll provide links to all of these guidance notes in the in the note of the meeting. So so now item 5, Mr. Trinick, in the position statement, until today there hadn't been a indication of any additional information beyond what you've said so far with regard to ratio. Is there anything else that the applicant is proposing to provide additional information on, Mr. Trinick?
Yes, simply an update to the cumulative landscape and visual assessment baseline, and that will be ready by the 17th of April. And again, I ask you to require that for the purposes of the inquiry. But that's all.
Can I catch that date again? Did you say the 17th of April?
Yes.
8th of April. So you're indicating to the meeting that if there is a need, or you're bringing that to my attention that there is a need for that, and you're asking me to request that for the purposes of the inquiry. So the parties have heard that. This is not an unusual matter with regard to inquiries, because the cumulative landscape, if you like, changes with the passage of time. Does anyone have any particular concern with regard to requiring that information now that it's been flagged up that is something that I would need? Are all the parties happy with that approach? And that as part of that, all parties would be given an opportunity to respond to that if they wished, in terms of further written submissions after it was submitted. Mr. Trinick, are you happy with that element?
Yes, sir, I am.
Well, thank you for bringing that to my attention. Given the nature of it, that you flagged up a need, I'm quite happy that I do need that for the purposes of the inquiry. So I'll request that, and again, that would be requested in the note of the meeting. Is there any other additional information that you have planned, Mr. Trinick?
No, sir.
Any other queries on additional information? It's essentially new information that would form part of the environmental impact assessment report. Okay, I think we can move on if everyone's happy to move on. I'm going to ask you to refer to Annex A of the agenda, because that sets out an initial view. I've had a good look through most of the submissions. I've looked through the council's position, and I've looked through the applicant's position in terms of procedures. And that table, in a sense, sets out in broad terms what I consider appropriate. So with your permission, I plan to just go through each topic area and just highlight how I think or what procedure we should follow. And if you do have any concerns about the procedure that we're proposing, or that I'm proposing for discussion, then please stick your hand up, or if you're having trouble with that, just interrupt. So with that introduction, I'll move on. In terms of policy and application benefits, I would propose that certainly initially it would be dealt with through written submissions, and I would ask the applicant to lead a statement of agreement to be prepared between the applicant and the council to cover economic and energy benefits, the Schedule 9 of the Electricity Act, Scottish Government policy, energy policy, development plan policies, including supplementary guidance and the like, and other published guidance. And that would hopefully get to a point where it's clear where the areas of disagreement are, and in light of that and all the other submissions that we've had on policy matters, then I feel that may be enough for me to write my report. If I do feel that there are further areas that I would like clarity on or an exchange on, then those would be dealt with by written submissions after the submission of the statement of agreement between the council and the applicant. So I don't think in this instance there is a need for a hearing on the matter, but some parties may have a different view. I'm going to come to, I know Mr. Finlay has his hand up, but I'm going to turn to the applicant first.
So we're content with that, with written submissions in this case.
And for the council?
Yes, sir. I think there's potential to reach a great deal of agreement in relation to planning policy matters, and a statement of agreed matters would be useful. I'll leave it to you, sir, and perhaps Mr. Finlay, whether there should be time set aside in case it's needed for a hearing session after that exchange of written agreements, but the council is neutral on that matter.
Mr. Finlay.
Yes, as you may recall from our initial objection, which was somewhat dated, we raised a number of issues that would come under policy, and I don't disagree that a large number of policy matters could be dealt with in a statement of agreed matters, provided we were part of that. But we are thinking more of the your reference to benefits and the current state of targets being met and the like. And our suggestion on that would be that alongside any statement of agreed matters, there could be written submissions, provision made for written submissions and rebuttal on policy benefit matters, with the prospect of a hearing session being held in reserve until you have considered those and determined whether you would wish a hearing session. So the problem that interested parties face, and it's not a criticism of your proposal or indeed either of the other parties, is that a statement of agreed matters between the applicant and the council doesn't necessarily engage with all the other parties. And to have a statement of agreed matters with all the amount of parties involved in this case, it can be a futile exercise. Can be, may not be. But we're very happy to take part in the statement of agreed matters proposal, but we do suggest that at the very least there should be provision for written submissions to update the current position, take into account new policies since party submissions were made, and rebuttals as appropriate, if that could be, leaving aside, subject to your judgment, whether you feel any hearing session is necessary. So that's our suggestion. It's trying to accord with the intent behind your proposal, but to add slightly to it.
Thank you, Mr. Finlay. And would you be content that the further written submissions would occur after the production of this statement of agreement, so that you can see the positions and then update your position? I think that's what I would be thinking, but you might have said in parallel there. So would you be happy that opportunity for further written submissions occurred after a statement of agreement was pulled together?
Provided the timetable allows for that to occur, with potential rebuttals if necessary, because if the applicant says something we'd wish to rebut it, then yes. I mean, the applicant and indeed the council may wish to make written submissions if they can't agree on everything. But yes, that would make sense. It would certainly shorten insofar as we were in agreement with what was in the statement of agreed matters, we could simply record that and there'd be no need to make submissions on them. So provided the timetable made provision for that, for subsequent exchanges. That would appear to us to be a sensible suggestion. So thank you very much, sir.
Thank you, Mr. Finlay. Before I come to Dr. Ford, Mr. Trinity, do you think, and then I'll come to the council, do you think the preparation of a statement of agreed matters is something that could be started relatively soon in fairly short order, in order that the timetable for the inquiry isn't elongated too much?
Yes, so we've already spoken about that within the team, and that can be done very quickly.
Okay, I'd be happy to lead on that matter and seek the council's input to get to a final document. Yeah, Mr. Burnett, before I come to Mr. Ford, does that sound reasonable to you?
Yes, I think the applicant and the council should have the first go at this statement of agreed matters, then others can comment on it. So I don't see a difficulty with that.
Yeah. Dr. Ford.
Thanks, sir. I'm generally in agreement with this process of trying to resolve things as much as possible. But I would echo Mr. Finlay's remarks that I think we and in fact I'm probably more inclined to say that we ought to put, if you like, into the diary maybe a half-day session on policy and drop it out if not required, as opposed to putting it in later. My view is that actually there is likely to be some differences of opinion here. And I think those differences should be aired. Whilst the core bits of policy may be clear, I think that when you go beyond that, there are actually quite a lot of areas of uncertainty and doubt.
Thank you, Mr. Ford. So I think where we are is the preparation of statement agreement in fairly short order in terms of in the timetable, an opportunity for further written submissions that builds in the opportunity for going back and forward in terms of rebuttal, and if required to have in our minds the potential for half a day hearing during oral process and fit that into the timetable. But that would be on the basis that if the reporter felt that there were matters that they needed discussion on, rather than just whether or not there was disagreement. I think you would have to leave that to our judgment. So is everyone content that we move forward on that basis on policy matters? It looks like it. We're getting thumbs up. And on landscape and visual effects, based on the submissions, I'm suggesting that be an inquiry session. We'll come on later on the agenda in terms of who wishes to participate in that and discuss that further. But just on the principle of what procedure, an oral session, and that be an inquiry, supported by some unaccompanied site visits by the reporter as well. Come to the applicant first. I think this marries in with what you had proposed anyway.
It does say, yes. In some recent cases, hearing sessions have been adequate. But that is because there's not much difference between the significance conclusions of the prospective professionals. There's not much to explore in cross-examination, in other words. That is not the case here. I think there are differences that need to be explored in formal evidence, and so I support the idea of an inquiry session.
Now, rather than going round everyone, is everyone content that there is an inquiry session? We're getting a thumbs up. Mr. Burnett, do you want to come in?
Yes, sir. In this instance, the council's preference would be for a hearing session rather than an inquiry session. I think we definitely need an oral session in relation to landscape and visual, because it's probably the main contentious issue between the parties. But I'm not sure that it's necessary to have a formal inquiry session, given a degree of overlap between the parties and really looking at the issues that could be best explored by you leading the discussions to find out the answers to questions that you want, rather than formal cross-examination. But of course, that's a matter for you, sir.
Thank you, Mr. Burnett. Mr. Finlay now.
Yes, sir, I would support Mr. Burnett's submission for two reasons. Primarily because in the experience of the interested parties professional team, hearing sessions have proved to be entirely adequate, if not more appropriate, for dealing with landscape and visual matters. There are differences of professional opinion, and in our experience, cross-examination is not the best way to elicit those and to judge them. It is more productive in our submission to have a discussion being led, and then each party's respective experts' view being taken at the same, effectively at the same time. I.e., if you're looking at viewpoint, whatever it may be, one for sake of argument, you can have the applicant's professional witnesses' view of it immediately followed by the council's, and then perhaps the interested party, Carol Anderson's witness, rather than having a much more drawn out process where you get the evidence from each separately. And in our submission, that can be of much greater assistance to you. The other point is that certainly the witness who we intend to call, Carol Anderson, much prefers.
I did it. I just wondered if I gave it to you.
I just think that if someone doesn't have their mute on at the moment and is having a conversation, or their phone is having a conversation with someone.
That may have stopped, I think.
Yeah, I think we are.
Grateful. That we have a much personal preference from Carol Anderson as a result of other inquiries. I should stress to add, not involving Mr. Trinick, but the giving of evidence is a stressful experience, and in our submission a hearing format is much more conducive to witnesses performing at their best. So for those two reasons, I endorse Mr. Burnett's preference.
Mr. Trinick.
I can assure Carol Anderson that being cross-examined by me is a stress-free experience. Aside from that, I do hold the idea of an inquiry session in this case, because I detect from the papers I've already read that there are issues of approach to assessment and calibration I think would be better explored through formal cross-examination. I think you will receive the information you need more efficiently and more deeply through that process than through a hearing session. So I'll leave it there. So it's your decision.
Thank you, Mr. Trinick. Certainly that's where I was, but I was going to ask about merit in preparing a landscape and visual statement of agreement, and that might be able to feel like fine-tune or refine the scope of oral sessions. Is that something that the applicant and the council and other parties who would wish to be involved in an oral session do think that's a useful exercise to go through on landscape and visual matters to prepare a statement of agreement? Mr. Trinick.
I think that'd be helpful. It might help you reach a final decision on what sort of oral process. Welch, my witness, has already prepared a tabular comparison of the findings of the 3 landscape professionals involved. And that is indeed why I say what I've said today. But I think that would, to publish that and circulate it, coupled with some text of a statement of agreed matters, will isolate where we are apart. And yes, I think that would help if we do that within a few weeks.
Mr. Burnett, from the council's point of view, if the applicant was to lead that, but the council were to contribute to that, akin to policy matters. Does that seem sensible?
Yes, sir. Certainly sensible to have a statement of agreed matters to try and narrow down what the real issues are between any parties and focus the oral sessions. But I would agree with Mr. Finlay said about the juxtaposition of witnesses on particular issues at the same time is, I think, beneficial within the hearing or the oral session. But it's definitely useful to have a statement of agreed matters in any topic in advance. So the council will be very happy to participate in that to try and narrow the issues.
It may be that we defer a little bit of discussion on this until later on, until I find out who the participants may be. But if you like, I could ask that just now, because that since we're talking about in terms of the range of parties that may wish to participate in an inquiry session, given that's my initial proposal, it'd be useful to know the number of parties that would wish to take part in an oral session. But Mr. Bruce, I think you had your hand up, so come to you, Mr. Bruce.
Thank you. I just wanted to clarify the note under the table says that the landscape inquiry would include the abnormal load route, but it doesn't specify anything about the construction route per se, which I think varies somewhat from the abnormal load route. And those two routes are the primary concern of East Lammermuir Community Council. So if you can clarify where you think they'll be covered, I'll be able to answer the question about whether we would want to be involved in the landscape and visual, the AIL route stroke transportation, and or the draft conditions elements of the hearings and inquiries and so on.
Then, in terms of that draft scope, it was pretty much a summary, and it probably should have included that based on what your submission was, recalling what you said in those submissions. If a statement of agreement is prepared, then hopefully that would essentially refine and set out in a way the scope of the inquiry, because that would be the areas of disagreement.
So that would include the construction route as well, the access route.
I'm going to take a note of that just now anyway, and include that. For the moment, the final scope of an inquiry would be, if you like, agreed further on.
Absolutely, I understand that.
Mr. Hamilton, I'm going to bring you in now because I think you.
Yeah, sorry. I need up Lammermuir SOS, and I have to say I'm quite ignorant about these sort of meetings and the procedure and so on. Am I led to understand that the inquiry will actually go up, trace the route, and go and see what it's like at the top of the hill, and so on? In other words, is this just restricted to dialogue on paper, or does the inquiry get onto the land and see for themselves, in my view, how tortuous the route is and how vulnerable we are living in East Lothian to the landscape visual impact? So, sorry, long way of saying, does the discussion go on site?
It can. What I had proposed was that a reporter would go onto site or near to the site on an unaccompanied basis, basically on their own, to spend as much time as they can. But often it's agreed between the inquiry parties that there'll be an accompanied site inspection that the applicant often leads and organises, and all the parties that are involved in the actual inquiry itself take an opportunity to visit the site. Now, we haven't got to that position yet in terms of a request, if you like, for an accompanied site visit. My view was that a reporter could do this on an unaccompanied basis, but there may be a different view from other parties. Just to give you a little bit of background of what an inquiry is, each party that wishes to take part in an inquiry session, not the overall inquiry that we're discussing today, but the oral session that we call an inquiry, each party will present evidence, and then they would be cross-examined, often by a lawyer. Those who've got different views would have the opportunity to cross-examine each other. And that's in a fairly formal setting. We, as reporters, would also ask questions, but observers and members of the public or participants in the inquiry that are not involved in the inquiry don't get an opportunity to ask questions. And all of that is there's a lead into that inquiry in terms of the witnesses prepare reports and recognitions, which is a summary of their view. That all happens in advance of the inquiry, and they go into the inquiry session and present that evidence and be cross-examined on it. So hopefully that's useful, Mr. Hamilton, in terms of what's involved in an inquiry. A hearing is slightly less formal. The reporter leads that, and the reporter asks questions of all the parties and their witnesses. That doesn't rule out others asking questions through the reporter, through the chair, but it's slightly less formal than the inquiry process. An inquiry process is normally used where there is technical evidence that and a disagreement that is needing, if you like, cross-examined, and the reporter to just clearly understand the party's position. So hopefully that's been useful for you. Stuart, I think you've got your hand up, and I haven't come to you yet. Stuart.
Hello, I'd just like to confirm that I'm supporting Chris Bruce's comments about the transportation route and the construction routes, which heavily affect us as well as East Lammermuir Council. So I just wanted to just underpin that we would find that very important.
Oh, I think I've indicated that in setting out that summarised draft scope. I think I could have better put that by including the construction route. So, Mr. Finlay, you've got your hand up, and you'll be very patient.
Yes, sir. Thank you very much, sir. Yes, certainly a statement of agreed matters can assist, particularly on the more technical matters that can be agreed between the parties. But in landscape and visual, statement of agreed matters quite often can have the leave other parties, third parties such as the estates who I represent and others who are unrepresented, at a disadvantage unless there's a proper session at which they can attend. I don't know whether you're proposing, there's nothing on the agenda to have a local residence session, but my understanding is there's some significant concern by local residents, some of which has been voiced today, to deal with that. If not, a hearing session is by far the more appropriate session to deal with such matters. So whilst the scope for us taking part in the statement of agreed matters, because we have a professional witness, we'll certainly would wish to be involved in that procedure insofar as we can. And given the witnesses involved, Mr. Welsh and Miss Anderson in particular, and I'm afraid I don't know who's giving evidence for the council, that should be a productive exercise. I am concerned that such an exercise doesn't leave other parties who are objecting on particularly visual grounds at a disadvantage, and ask you to take that into consideration when considering the format of any oral session, and or whether there is any appetite for a local resident session to enable you to get their views on visual impact.
Thanks for that, Mr. Finlay. Dr. Ford.
Thanks. So firstly, can I echo that point Mr. Finlay's already made about the community will want to be involved in the process of the building up to any oral session. I'm not sure how we would do it, but certainly I think our intention is that we are involved in the landscape and visual impact session. It's obviously an important consideration for this application. I've also got a second suggestion for you, which is that I'm aware that the community, and I've heard it from the Community Council as well, but the community generally are very concerned about the AAL and transport generally. So my suggestion is to you, sir, that we move it into the next item that is discussed, because I think some of the other items are less contentious is the word I'm going to use, but more clearer. So my suggestion is that you actually do have an oral session on AAL and transport, and that we kind of deal with that next on the agenda. Don't wish to take over your agenda, sir, but it just seems sensible from the point of view of the issues that are out there. And also, just to reinforce Mr. Finlay's point, that I've certainly indicated, and I believe it's quite normal to have a community session, perhaps in the evening, for members of the public to turn up and give their views on the proposal. That's quite an effective way and efficient way of contributing to the inquiry and allowing people to have their voice. So I would certainly support that recommendation.
Thank you, Mr. Ford. Just before I bring Mr. Mitchell in, just to kind of highlight what we've done in the past with regard to evening hearings. I think we're calling them community hearings. They have been targeted towards third parties. They are those who have opted into the process. It's not an open public meeting. It's those who have indicated that if they wish to take part in this inquiry process. I think there's up to 40 or so bodies, including the applicant and other parties that are represented here today. So it's not just the people here today. So it would be open. Those sorts of hearings have been open to those who have opted in, if you like, to the process. It would not be a public meeting, Mr. Ford, but it would be an opportunity, the way we've run them in the past, if there was a feeling it would be useful in this inquiry, those who wish to make statements would make their statements in front of the reporter, and the reporter would be able to ask them questions and ask questions of the applicant on the back of what the third party has said, but an opportunity to be heard in a not in an inquiry situation where you're being cross-examined, and that has worked well before. So if there is numbers and an appetite for that, that's certainly something we could consider. But before we come to that conclusion, I'm going to bring Mr. Mitchell in because you've been very patient. Mr. Mitchell.
Thank you very much. I'm a lay person. I'm a member of the public. I live at Luggett, so I'm on the route of the overload where it would significantly affect us. And I just really want to mirror what Mr. Finlay and Dr. Ford have said. And so, I mean, they've said it much more eloquently than I can, but I stuck my hand up before they spoke. So I'm just really backing up what they and Linda Shaw-Stewart said as well, that there are a lot of people that this is going to affect on the ground, on the routes. And it doesn't feel at the moment that we're getting the sort of professional representation as individuals. We are on the back of what Mr. Finlay and Mr. Burnett are doing, but they're not working for me in particular. But what they're doing is obviously objecting to the application. But it doesn't necessarily that it might be that they bring up the arguments that I would like to see, but we're not in contact directly at the moment. So that's all I would like to say at the moment.
In terms of taking part in any oral process which is discussing landscape and visual effects, including those of transportation routes, is that something that you would wish to take part in, Mr. Mitchell? Sorry, I think you're still on mute.
If I felt it was that this part of the process wasn't being represented well enough, I may well commission my own reports to be able to put forward, which if it supplements what's been done by others. So possibly, Mr. Bray, possibly I'd like to reserve my position.
Okay. Thank you, Mr. Mitchell.
Thank you.
Mr. Collins.
Yes, hello. I'm also a local resident. I live in Stenton. Not wishing to labour the transport point, but as well as the AIL route and the HGV route, could you also consider where other traffic might go, the lighter goods vehicles or the workers' traffic? Because at the moment, they would be free to come through Stenton and basically go wherever they would like. And also there'll be other people who don't want to go and dice with the HGVs who might also divert through Stenton. So there's three strands to it really: the AIL route, the HGV route, and the non-HGV traffic.
Okay, thank you, Mr. Collins. I mean, we'll probably come on to just discuss that a little bit more in terms of my little list, because transportation was if you like, an item I had considered separately. Just now we're just looking at the kind of landscape and visual impacts of the transportation issues, and we'll come on to what the parties feel is required in terms of procedure for the route in terms of transport and traffic impact and such like. We'll come on to talk about that just in a minute, if you don't mind. But are there other parties in the meeting that you've all obviously opted into the process that feel that an opportunity for third parties that wouldn't necessarily be resourced to take part in an inquiry to be heard in an evening sort of session, in front of the reporter, to give your view, either to restate or develop what you had said originally in your submissions? Does anyone think there is merit in that? Is there if you like, enough parties to make that a meaningful exercise? Mr. Hamilton, you're on mute, but I'm taking that as a thumbs up for that process. And
Very
Mr.
good.
Mitchell as well.
Sorry.
And Mr. Collins is happy with that. Mr. Bruce?
Yes, thank you. Just another point of clarification. I suppose the East Lammermuir Community Council submission is largely based on a survey we carried out with a large number of responses. So if you are suggesting that a community hearing session could take place in which parties that had opted in could contribute, does that mean I can attend as the sole speaker on behalf of the 70 people we surveyed, or would you accept perhaps a representative from the 2 or 3 majority perspectives that came out of the survey? So it did demonstrate a spread of opinion. We could probably work to seek to get people to speak from those different perspectives. So it's a question of my representation of a much larger cohort of people who we surveyed.
From the point of view of groups like the community councils, for example, or yourself who are representing an umbrella group, then it would be a matter for the group how they're to be represented. How we ran these groups gets a period of time and they are given the opportunity to say what they would like to say during that time. There'll be time allocated for questions, and then we move on to the next, and do that within an evening. It's manageable. Say if you have maybe up to 10 sort of, either groups or individuals making their representations. That could work in an evening. Much more than that, and it gets quite difficult to fit that into an evening. But it would be a matter for the group how they're represented. That's what I would say. A third party, slightly different. Generally, it's an individual who represents themselves. But Mr. Robertson, do you have your hand up?
Good morning, sir. I live at Standing Stone, which is an area where the applicant plans to put in a new part of track. So we'll be heavily impacted on by lorries. But the transient nature here is that we have new persons in the community who have maybe not had the opportunity to understand the application or the impact on them. So I think a hearing for local community people would be very beneficial to get their views as well.
Thank you for that. Hopefully you understood from what I was saying that, that because we're in the inquiry process and the application has been through, we're dealing with managing if like those people who have contributed so far. If you like, we've narrowed that down by going through the opt-in exercise. So there's those who've opted in, but there is nothing to stop individuals, if you like, talking to other individuals to get their viewpoint. But it would only be those who have opted in. It wouldn't be a public meeting. You can imagine that's actually quite difficult to manage and not that productive from our point of view in terms of hearing distinctly what the concerns are. Dr. Ford, I'm hearing or I'm detecting and I'm noting down and that it looks like an evening community hearing held around the time perhaps of any other oral process is going to be useful for those parties who have, or at least some of those parties who have opted in. So that looks as if it would be a useful addition to the procedures that we might agree today. But Mr. Ford.
Thanks. Just to say that in talking to members of the community, which I've done in the last few weeks or so, they go through the usual concern about, oh, what is this process involved? How do I get involved? And then the kind of daunting prospect of potential witnesses and that kind of, when you get into that kind of language of evidence and that kind of thing. But then they get incredibly relieved when they hear there's an opportunity for them just to voice their view to something like a community hearing. So I think there's strong support locally for a community hearing. And just to apologise, I did not intend to allude to the fact that it was a public meeting in the sense it was open for all to come. I'm all aware of the process. I'm sure you are. So thank you.
I was actually just stating that for effect in a way, so that everyone knew that as those who've opted in. However, what we've generally done in the past is allowed others to come in and observe, and that's been quite useful for other members of the public just to be able to observe the hearings and the inquiry process as well in terms of an inquiry session. Okay. I'm detecting from that there are, and I may be wrong here, but there are three main parties that would wish to take part in an inquiry or hearing, formal hearing session, and that's the applicant, the council, and those that Mr. Finlay represents. And then there are a number of other groups who would wish to be heard at a community meeting. Am I accurate in that, Mr. Ford?
No, sir. We would like to be present and involved in the landscape and visual impact hearing, whatever form it takes. I don't really mind. We haven't yet formed how we will do that, but we certainly intend to do that. It's an important issue for this proposal.
Yeah. Thank you for that clarification. Mr. Bruce?
Yeah, I think we would wish to be at both as well as the community council.
And if there was to be an inquiry, a formal inquiry process, you would wish to be represented in that.
Yes.
That would probably mean that there would be no need to take part in any evening community hearing, because I will have heard what you had to say in the inquiry. So just so we're clear on that.
Well, I heard you say that at the community hearing, I might invoke the assistance of 2 or 3 others to give the spread of opinion that we heard through our survey, but I'd have only anticipated coming to the inquiry myself. So,
well, I think what I would be asking is, what I'd be asking is for what the community council wish to do, and what I've heard there is that the community council would wish to take part in the inquiry process, and I wouldn't envisage inviting parties to the community hearing other than the applicant to answer any questions. Just to keep it as streamlined as possible, because I would have heard your evidence before or perhaps after. Ms. Shaw, I think, sorry, Ms. Stewart, you've got your hand up. Mrs. Stewart, are you there?
I keep on my mic, muting my mic.
That's fine. That's fine.
Just to say that I think, is there any possibility that if there is a community, element to it, that even though I wouldn't, as a representative of Dunpender Community Council, attended the community event, would somebody else who, could coordinate that from the community council, but I would be part of the inquiry itself?
Well, I think what I've said to Mr. Bruce applies, is that I would be asking the community council how they would want to participate, and if you're wanting to participate in the inquiry session, then depending upon the numbers for the community session, then I would give priority to others. I think is where I would be, in that we would have heard your evidence. I wouldn't want to be firm on that at the moment, because we just don't know the numbers. But it may be that priority would be given to those who haven't had an opportunity in other parts of the process. So hopefully you can be reassured that I'll take on board your view, but that it may be difficult to give parties the time if there are others who haven't been part of the inquiry process.
Okay.
But I've heard what you've all said so far today, and am I right in saying then that both the community council, Mr. Ford's group, and Mr. Finley's group, and the council and the applicant are all wishing to take part in the formal oral session, and would be willing to present evidence, and whether it's a hearing statement or an inquiry report in advance? Is that what I'm hearing?
Yes, for me.
And Mr. Bruce, I'm not going to ask you to speak or stick your hands up because you're driving at the moment. So to be honest with you, I'm not sure that. You're in the back seat, because I was going to say if you are driving, I don't think that's particularly safe. So I'm glad you're not driving. Mr. Trinick, you've heard what we've been discussing. Do you have any thoughts on what we've discussed so far from that point of view?
As far as the general landscape and visual effects of the development are concerned, I still think an inquiry session is appropriate. Clearly, there's a subtext here about a transport route, whether it be AIL, HGV, or other. I suggest that following this PEM, quite apart from taking standings on the need for an inquiry session for visual effects, through a statement of agreed matters and a tabulated comparison of the findings of professional witnesses, people should also make submissions to you about precisely what they want to say and hear about access, You can then decide whether or not oral process for that is appropriate, and if it's to be oral process, whether a community session is best, or whether it should be wrapped into the landscape and visual session.
Okay. Certainly the community session that I've been discussing so far has been focused on the landscape and visual elements of the proposal, which includes part of the transportation route as well. But it's focused at the moment, as I understand, with regard to the landscape and visual effects. If through the discussion through the other matters that it becomes apparent that it's actually as important to those who've opted in from the community or third parties to have a more open community session, that a number of matters could be raised, then we could look at that as well. But I've got a note of who the parties are in terms of the oral procedures, and I've heard what everyone has to say on that one. So I will take it away and think it further, including your last comment, Sir, Mr. Trunick, and come to a conclusion in the note of the meeting. If I can take Mr. Ford's lead and jump to the transportation, well, let's call it transportation topic, although we discussed it, that I did feel that as a first procedure that the reporter would write out to different groups potentially, or the applicant or the council, for further clarification on transportation matters, and that that would be done including and probably after an accompanied site visit to the general area, so that the reporter is aware of the general feel of the area. Do you think there is Mr. Ford, a benefit from if we are to have a community evening hearing, benefit from not just focusing on landscape and visual effects and widening that out to transportation matters also, over and above any questions that I have for any a group or the council or the applicant? Would broadening the scope of our community hearing to include transportation matters seem reasonable? Mr. Ford.
My view is that actually, whilst a lot of the community have grave concerns about the transport impacts, both AAL generally, that actually I think there's actually still merit in an oral session specifically on transport, including the three elements that have been raised. I have come to this application relatively recently, but so I'm going through the preliminary process of kind of looking at the different elements, and I'm a little surprised at the level of information on the transport and section, basically. And I'm aware that the council have also raised concerns about the transport routes, the AAL in particular. So my view is actually there ought to be a separate oral session, whether that's hearings or inquiry. I'm open-minded about, but there actually ought to be a separate oral session on the transport aspects generally, because I don't think the effects are fully quantified into the EIA, and certainly I had, I don't think you're necessarily aware, sir, but these types of proposals are my bread and butter work activity across the country, and therefore I'm used to assessing what the likely impacts are going to be and the areas of uncertainty. But I was a bit surprised that the AAL and the transport impacts, if you like, were not being adequately covered in the AA, and therefore my feeling is that there ought to be a separate oral session on it, actually, as well as potentially hearing the voices from the community generally. In terms of whether you leave that open in the community session, my view is actually that community sessions are best left to whatever the community want to say. So rather than making them about landscape or visual impact or particular some aspect, they're actually just generally open. And my view is that a lot of these concerns are likely to be dealt with properly in an oral session on transport. But I think there'll still be some left over where people, particularly residents on the routes, are affected and they want to give their views, basically. Thank you.
Thanks for that, Mr. Ford. Could I come to Mr. Burnett, actually, before I come to Mr. Baldy, because he's got his hand up. In terms of because I know the council maybe had a different view from that in terms of procedure for transportation matters. Do you hold Mr. Ford's view that a hearing is required to discuss transportation matters from the council's point of view?
I think, sir, that so long as the AIL is included, as you've indicated, in the landscape and visual section, then the council's fairly neutral on whether there be a need for a separate hearing on other transportation matters. I think we indicated in our position statement that a hearing might be appropriate, but we're neutral really on that, provided the AIL is included in the landscape and visual effects. And lest I forget, sir, I was going to slightly go back on to your order for the historic environment you suggested.
Oh, yes, I'm coming to that. Don't worry. I just jumped because we were talking about that. So that's my fault for maybe not being clear, Mr. Burnett, about I'm coming back to that. But it's just because we had delved into transportation. Mr.
A similar issue in relation to the historic environment, sir, that if that's to be by further written submissions, that would be fine, with the exception of the trap rain law, which is obviously an important point for the landscape and visual, and that element may overlap with landscape and visual, so it could be included in the landscape and visual hearing, and then the rest of historic environment could be done by written submissions. So it's just a
okay. We'll come to discuss that just in a second. Mr. Baldry, and then to Mr. Trinick after that. Mr. Baldry.
Ford said about the need for an oral session on transportation. I'm not an expert in this area at all. I'm a local resident. But from the information which the applicant previously provided, including the additional information, to my mind, there are still many unanswered questions and uncertainties about what is actually proposed in terms of transportation. And I feel those would be best explored through a formal oral session, and whether it's a hearing session or an inquiry session. And that would provide an opportunity for the reporter to hear different points of view, ask questions, and hopefully fill some of the gaps and challenge some of the assumptions or inconsistencies which there are in the applicant's submitted documentation to date, and still need to ask the objectors to explain, if necessary, more fully the reasons for their concerns.
Thank you, Mr. Baldry. Thank you for that. Mr. Trinick, you had your hand up.
Yes, sir, thank you. As between East Lothian Council and the applicant, the AIL issue boils down to landscape and cultural heritage and nothing else. And we've written, you've seen the letter which WJM have written to the council on that point and on other points. The landscape side of the East Lothian concern can be explored in the landscape session. That's fine. The historic environment side, I disagree with Mr. Bennett. I think that needs to be dealt with as part of the historic environment topic, because it is distinct. It's a different topic, different methodologies, different approaches, different witnesses. So I think that should be a separate session. As to the concerns we've heard this morning from members of the public, from Mr. Ford, I'm a little bit unsighted on the scope of the representations that they want to make. And my invitation to you would be to request further written submissions from all parties who want to take part in a transport session within whatever time you specify after this meeting, so that we can all see what it is that people want to say. We can see the scope of what's to be represented, which may not yet be in representations already before you. On the basis of those representations, you can then decide whether or not oral process, likely a hearing, certainly not an inquiry, is needed to deal with matters. But I would certainly separate out the landscape and visual and historic environment side of the AIL issue from all other transport issues. Thank you.
Look, Mr. Trent, sorry, I was just making some notes there. Okay, we've jumped about my little table a bit, but it's been a really useful discussion, I think, and I've heard what the council's view is on the historic environment. Is there any disagreement with how I've set out with regard to other topics? I mean, I've indicated there that on biodiversity, I would like to ask a number of questions on access and battery fire risk. We can leave conditions. We can come to that at the end. But were parties generally content with how I've set out how we deal with the other matters in terms of further written submissions? Mr. Chinook?
In most cases, yes. I do ask for a hearing session for cultural heritage. I think it's a better way of clarifying and exploring the differences between the professional witnesses, because those differences, from my reading of the papers, are as much about approaches to assessment as about the conclusions themselves. I feel you will benefit hugely from what will need not be more than a half-day hearing to deal with this issue. So that is my request, a hearing session for cultural heritage. We can also take in the cultural heritage aspects of the AIL concern expressed by East Lothian Council, and maybe by others, if they want to take part. In relation to biodiversity, you'll have seen again the letter we've sent to East Lothian Council. That will take its course. I don't want to talk about that here, but I think we're content with written submissions. In terms of the recreational aspect, Green Network, Core Powers, Rights of Way, again, we've written to East Lothian Council. Subject to that, yes, I agree, written representations. We dealt with the AIL. Battery fire risk, I'm not sure we need written representations. That to me serves as a matter for the conditions section, given that safe for access and a supply of water in the event of a fire risk. I think it's tolerably clear that the BES issue is not really a planning matter, and that's on the advice of the Chief Fire Officer. So I would relegate that to conditions. And as to your last topic, all other topics, we've given that some thought and we can't think of any. So thank you, sir.
Thank you for that. I may not relegate, I might promote battery fire risk up in the leagues again, in terms of, that was just a couple of questions that I had. There wouldn't be extensive written submissions, but certainly I think it would be useful to have further written submissions in advance of the discussion on conditions. So it's likely that I will pursue that, Mr. Trinick. It wasn't extensive submissions, but I think it would be useful to get a couple of questions answered in advance of any conditions discussion. Coming back to the council on a hearing session on cultural heritage, which because I've not drafted up a scope, I think the scope of that would have to be discussed and agreed. But does I know you indicated it may just focus on at the very least one monument, but are you generally content with progressing with a hearing on cultural heritage issues on the proviso that we will narrow down the scope of what that would be, Mr. Burnett?
Yes, if the applicant's content with that, a very shortish session on cultural heritage, I think, would suffice. And I agree. The council will respond to the applicant in terms of the biodiversity, and I don't envisage any need for any oral process in relation to that or the other matters other than the ones that we have already talked about. And there'll obviously be a need for at least a reserve an oral session for conditions and other matters, including battery fire risk, could be dealt with by written submissions as far as the council's concerned.
Thank you, Mr. Brett. And coming on to the letter, it may be useful that any written submissions that the reporter sends out awaits some of that discussions. Would it be fair to ask that you keep your final responses, if you like, within the inquiry and share it with all the parties? Mr. Trinick has shared the letter with us. And it would be useful to see your response, and then that if that response is prepared, then that might influence some of the written submissions that are made by the reporter. So, is that reasonable to kind of ask that whenever you do respond, that is shared with the inquiry, Mr. Burnett?
Yes, so we'd be happy to share the response. I think for today's purposes, if anything is required after that, it'll be purely written submissions as far as the council are concerned. Don't envisage any need for any oral hearing sessions to be scheduled on any of those issues.
Okay. Mr. Trinick, are you content that some of the further written submissions that we discussed today may await the council's response and any council's final response? We don't necessarily need to see any correspondence going in between, but I think the council's final response would be useful, so that if you like, piece of correspondence is concluded and that we see it. Is that reasonable, Mr. Trinick? I don't want to cross over between starting written submissions and your negotiating matters with the council.
That seems sensible, sir. Let's conclude our correspondence and then written submissions. No, I agree with Mr. Burnett. We don't need more than written submissions.
Okay, thank you for that. Now, some of the parties have mentioned conditions, and we've not discussed that yet. I would plan that we, if you like, we follow a fairly well-trodden path of a statement, if you like, generally led by the applicant, which sets out where conditions are agreed, how they've taken on board the views of consultees in preparing the conditions, and identify where there is a disagreement with the council or with other parties. And that's a process that generally involves the council and the applicant in the first instance, and then other parties that have an interest in that could then have an opportunity to either contribute to that statement before it's finalised, or to have a discussion at a hearing session. So I would really just, I'm assuming that the council is more than happy to be involved in whatever process with regard to conditions and potentially legal agreements in this case. But are there parties, I know Mr. Bruce, your submission has set out quite a number of comments on conditions, but are there other parties that would be like to be actively involved in the procedure for conditions? Mr. Bruce, you had your hand up first.
Thank you. Hope you can still hear me. The applicant has indicated already that they would be willing to commit to conditions which seem to go quite well beyond the standard ECU conditions might require. Can you just confirm that that is something that you would consider within this process and won't just stick to the standard introductory documents?
Unfortunately, you're breaking up a little bit, Mr. Bruce, but what we won't discuss today is the nature and the detail of what could be in conditions. But I'm taking from what you're saying is that you'd like to be involved in the conditions process. Yeah. Okay. And Mr. Finlay.
So I'm not certain. We'd certainly like to register our interest in that session at the moment, or in any process, and whether we actually need to be involved remains to be seen. But in particular, in the light of the additional information that we're getting about the grid access route, it may well be we have very specific comments to make about conditions relating to the grid access in due course. But it's far too early to. I know that to envisage that. I know that permission is not being sought in respect to that route. It's just going to be included in the AI, but that doesn't mean you can't impose conditions on it.
Thank you, Mr. Finlay. Now, before I bring Dr. Ford and Stuart back in, what I would envisage is that the applicant and the council prepare a statement setting out draft conditions and indicating any areas of disagreement. And if there are other parties involved, they would be asked for their submissions on that statement in advance of any hearing, so that we could have that discussion, so that there would be an opportunity to contribute, if you like, to the discussion on conditions once the applicant has been given the time and opportunity to discuss these things through with the council. Does that sound reasonable to those third parties who would, or other groups that would wish to take part in discussions on conditions that you see as being put forward as potential draft conditions if ministers were content to consent the proposal, but that you'd be given the opportunity to be able to write down your concerns essentially and take part in an oral session. Mr. Ford.
Thanks. Just to confirm that we're happy with the usual process, which, as you say, involves the applicant and the council liaising and sorting the bulk of this out, and then just the opportunity, if needed, to come in later on to the process. Thank you.
Thank you for that. Ms. Shaw? Probably muted at the moment.
Yes, that's fine.
Fine. And I got a thumbs up from Mr. Collins as well. And I'm not seeing, yeah, that's good. Not seeing any other comments. Item 7 on the agenda is participation, but I think through our discussion, I've got a fairly good idea on who wishes to be represented in the sessions. Just in case I don't pick that up properly, I would propose that in my note of the meeting that I give a short period of time, say 7 days, for people to confirm that I'm accurately representing what you want to be involved in, rather than going through it again. Are you happy with that? That I will set it out as far as I understand in the note of the meeting, and allow all the parties that have opted in to kind of clarify their involvement. Does that sound reasonable to the applicant, first of all? So I don't want to go over ground that we've probably covered already. That will include, I think my thinking is that an evening hearing session for those third parties that have opted in would be broader than landscape and visual matters. Well, just for clarity, I think that would be useful given the comments that have been made by those representing the community, so that if an allocation of time is given, then it may well be a matter for the individual what they allocate to that time. I think I've been hearing that in the discussion today. Could we break for a moment or two now then? Because I would like may be difficult to get the community councils and Mr. Ford and the council and the applicant, Mr. Finlay, all together. But I think that there are three parties that, if you like, have indicated that if they have professional witnesses that may take in an inquiry for landscape and visual matters. Is it possible that those three parties can get together over a break and discuss dates? So that would be the council, Mr. Finlay and Mr. Burnett, and then come back to the wider group and see if those dates are reasonable. What I would, one of the reasons why I'm breaking, and it relates to a wider point at the end of the agenda I was going to pick up, is that as you'll be aware, the GPA are under significant pressure, as are many organisations at the moment, with regard to the level of casework that we have. And there's no guarantee that it would necessarily be the same reporter that you see today that may take the matter further. We're having to be very flexible in terms of how we use our resources. If there was a change, it would have a natural break, for example, after the PEM, before we get too further down the track. But so I would like those three parties to come up, if you like, with more than one, and to give us your earliest date that you could agree, and then another 2 dates, let's say a couple of months after each one, just so that if that first date is not manageable for any reason, that we have other dates in the diary, or at least penciled in. You can also obviously give consideration to what Mr. Trinick said about the publishing of additional information as well. And I know a number of the parties indicated that that might impact on the inquiry timetable. But would those three parties be willing to go into a breakout room? I'm not saying you can't have a cup of coffee just now, but and discuss timing of inquiries, perhaps identifying a week that all the oral processes could take part in, and come back with the earliest opportunity and a couple of later weeks as well, so that we do have that if things slip or our resources don't allow the first date. Mr. Trinick, would you be happy to do that?
I'm happy to do that. So before we break, I just want to set the scene in one sense. You will be familiar with what I'm about to say, as will Mr. Finlay, from a recent PEM. This is a project which has, from ESO, a gate to phase one offer, meaning that a 2030 connection is envisaged, and that the project's capacity is strategically aligned with Clean Path 30 regional capacity aims. Therefore, although you can't formally prioritise this project in terms of getting to inquiry, we would ask that consideration is given for setting as early a date as possible for this inquiry, and to remind people we've already canvassed the 13th or the 17th of July. I believe that Mr. Finlay and his team are available for those dates. We don't know about the council, but the proviso that if we have a hearing for cultural heritage, that'll be on the 16th and 17th. But our target is 13th to the 17th of July, and bearing in mind what I've said about NISO. Thank you, sir.
Thank you. As long as you'd be willing, Mr. String, to discuss and look towards later dates, if that's in order that for any reason, if things slip, that at least the project has got other time identified. So we are actually trying to be proactive in making sure that if the resource isn't there to move the inquiry as quickly as the earliest date, then at the very least there is a fallback position available, because everyone's diaries do become very tight. Mr. Burnett, from the council's point of view, are you happy to take 10 minutes with those three parties? I can get you popped into a breakout room, and we can come back in a little while. Mr. Burnett?
Yeah, content to do that, sir. Just wanted to clarify how many days you thought you were looking for, because would be 2 days you're envisaging for a landscape and visual and cultural heritage combined with the conditions, or a longer period, because that may affect which weeks are available.
Well, I've indicated a week because if you're talking about a day for cultural heritage, maybe it'll be a half day, but like half a day for conditions. We have an evening hearing and a couple of days, maybe 3 days, depending, because there's a number of parties involved in the inquiry for landscape and visual. So I was thinking that if you could identify a week, or at least a week that the parties had most of that week available, then we could work on that basis. I'm not firm yet in terms of how long we think will take. Mr. Trunick, you're going to give us an idea on how long things are going to take.
I would say 3 days is what we need.
If things like site visits, accompanied site visits are requested and such like that, might elongate it. So I'm happy so long as the applicant would be willing to do evening sessions during that period. Then you look for 3 days minimum. If you manage to block off 4 within a week, that I'm happy with that. But Mr. Ford, you had your hand up before I go to Mr. Finlay.
Just to say, sir, we would like to be involved in this process. We are also presenting professional witnesses, with all due respect.
I'm happy to pop you into the room. Apologies if it sounded I was excluding you there, Mr. Finlay.
We're very happy to make progress on dates. I'll reserve our submissions as to whether a July date is feasible for when we return, but we'll provide some. We will seek to agree potential dates whilst everyone else is having their coffee.
Well, we can agree a longer period of time.
No, I think we're all keen to get on with it. So I think we only need 10 minutes to agree on other dates. But Mr. Trinick's right in terms of the July dates, but we raise a severe question mark over the practicality of that.
Okay, so I have 4 parties who are happy to discuss timetables on Mr. Ford, the council, the applicant, and Mr. Finlay. Now, if Connor is listening in to the broadcast, then if you can pop these gentlemen into a breakout room. It might not happen instantly, gentlemen. It'll happen just in a little minute. So if you stay on, and if we 10 past 12, that will allow you a little bit more than 10 minutes, and you might even get a cup of tea. Certainly, if Mr. Finlay, Mr. Trinick, and Mr. Burnett and Mr. Ford can stay on with your videos so that Connor can talk to you, and Connor will probably put a delay, like a panel on the live broadcast, to indicate that we're taking a break until 10 past 12. Okay, so we'll see you all back at 10 past 12. Okay, I think everyone is starting to make their way back to the meeting after that short break. Do we have all the parties that were discussing dates back in? I see Mr. Finlay, Mr. Kelly, Mr. Trinick.
Not Mr. Bennett yet, I think.
Don't think
Bennett's he's just rejoining now. We're just dealing with that.
So we'll just pause until we know we've got everyone back in. So Mr. Burnett's back as well, I think.
I think we've lost Mr. Finlay.
I see Mr. Finlay.
Oh, there he is. That's good.
I'm here.
Is Dr. Ford? I can't see Dr. Ford, Connor. Mr. Ford now back. Now, I am noticing that there are not as many participants as there was earlier on this morning. Does anyone know of any reason, or do you think they've heard what they need to hear in terms of the main part of the agenda, and they may have other business to attend to? But if you know that we're waiting for someone, then please let me know. I see Mr. Bruce isn't there. Any explanation, Connor? You've not had any of the parties contact you to say that they're having difficulty reconnecting?
Nothing currently. Everything. Everybody from the room, I believe, is back.
Well, let's work on the basis that all the parties that were here earlier on have indicated what they wanted to, and we can proceed with the rest of the meeting with a couple of items. Is everyone content to proceed? Yeah. Okay. Well, on the agenda item 8, it is we're to discuss dates and formats for the inquiry and hearing sessions. At the moment, we're talking about an inquiry session for landscape and visual hearing, short hearing for cultural heritage and for conditions. Although the process of a statement of agreement for landscape and visual effects may persuade the reporter that a hearing is best, but that would have to be made at a later date, but in good time in advance of a hearing. But we'll proceed on the basis that it's an inquiry at the moment. So that's what we're talking about in terms of oral sessions. The scope of that landscape and visual oral session, we've heard representations today that should include construction routes, and I will add also to the draft scope cumulative impacts, and that may well relate to also some of the additional information with regard to cumulative impacts of what the applicant described as the single project. So a slight widening of the scope. That scope is to be refined and agreed between the parties in advance after the statement of agreement. We indicated earlier on that the scope of the conditions hearing and the scope of the cultural heritage hearing would be determined at a later date by the reporter. I think we all agreed to that. For these sessions, would you advise that they are best done face-to-face or virtually? But I do notice that Mr. Ford has his hand up. So before I ask that question, Mr. Ford.
I wonder whether it would help the community session to actually have a session on transport, an oral session on transport, basically. I think it would take the tension out of the community session, and I think it would generally be helpful in terms of progressing the inquiry generally. At the end of the day, so it's a matter for you, but I also wonder whether the cultural heritage aspects are also quite heavily linked to the transport impacts as well. Whether there's a fit between those two sessions that actually almost it's cultural heritage and transport.
I think as Mr. Trinick mentioned earlier, they are will involve different specialists. There are different topics, different impacts potentially. So I'm content to keep them separate. What I have indicated earlier on is that a community hearing, the scope of that would be broadened to include transportation and other matters. I did hear what you said earlier on with regard to a formal oral session on transportation with the key parties, and I'll consider that before I come to conclusion in my note. But thanks for that in advance of asking the question about face-to-face and virtual procedure. Mr. Ford, since you were talking, do you have any preference with regard to face-to-face or virtual procedures? If all oral sessions are close together, would it be best to deal with them face-to-face in the locality?
My view is yes, it would be. I think there's two benefits to it. One is it's an easier discussion across the room, basically. But secondly, also it's easier for the community to observe it, even if they're not being actively involved with the process. So yes, I would recommend. Conditions is perhaps a different session and can be virtual, assuming there's going to be one. But yes, I would think oral session is better for in person is better.
And from the applicant's point of view, the potential for the oral sessions to be virtual or face-to-face, you've heard Mr. Ford there suggesting that conditions, may not necessarily need to be done at the same time, could be virtual. That's often the case. Do you have any thoughts?
Yes, I think a strong preference for in-person oral sessions. For the reasons Mr. Ford gives, I think it involves the community in a better way. It enables exchanges outside formal oral sessions between the parties, which help the process generally altogether much better.
Is there any of the parties who would advocate a different approach to in-person?
So I would just echo what's been said so far. I think in person would be best for everything apart from potentially conditions, but generally in person is better.
So moving ahead on the basis of in person, unless other circumstances would dictate otherwise, perhaps, but there seems to be general agreement on that. Happy to proceed on that basis. And dates. Mr. Drake.
So we, in the breakout room, just to cut to the chase and perhaps shorten the debate, we've all agreed a date of the week of 12th October. It's later than we want, but we accept the reality from the applicant's side, 12th October.
So
for as long as we that week, I suggest you set aside the week for the moment, and we can refine exactly what take place when later.
And the parties that were in the room all happy with that? Given that it's the 12th of October, my homework for you to prepare 3 dates was on the basis that I had seen some dates in June and July, and that's why I was asking you to look at later dates, because as I've highlighted, resourcing may be an issue. I'm happy to work on that basis. That will make the resourcing of it far more likely for that date. The June, July earlier dates were going to be difficult. Are all parties happy to block off that week for the moment? Is there any preference within that week how we order matters? Mr. Trinick, have you given that any thought?
Well, yeah, so we've simply had a discussion about the week. We don't know about individual works availability on which is listed on particular days. Can I suggest that following this meeting, that all parties provide you, well, we'll try and coordinate and provide you with a suggestion as to when the evidence, particular evidence takes place. Subject to that, I would suggest if you put landscape and visual up front, starting on a Tuesday, I suggest, and allow Tuesday and Wednesday. You allow a cultural heritage half-day hearing session on the Thursday, and a condition session if necessary after that. If there needs to be other oral process, that can be accommodated before the end of the week on a hearing session basis. And that's just me setting the scene. I have no idea if that's acceptable to others.
I mean, I think I would work on the basis that once my once my note is out, that'll set out a little instruction to the parties, probably for the applicant to lead that discussion and come back with. But if I were you, I'll just wait until the note's out and you get that instruction, and then we can move forward on that basis. But I would like to build in an evening for the community hearing also within that. But I'll set out the parameters of what we'll be asking you to do, and we'll set that out in the meeting. Although the community councils were not involved in that discussion for the 12th of October, it's often very difficult to get everyone to agree, but I'm sincerely hopeful that that will be suitable for everyone. Very difficult to get time that everyone is available. So we'll try and end that in within the note. The other matters with regard to timing will probably be set out on the note. It's far too complicated, I think, to try and discuss. You've given me an indication of when things are going to happen in terms of AI and the sequencing of further written submissions after some unaccompanied site visits. I think it's too complicated to discuss. If you just trust that I try and set those out in the PEM note as best I can, and offer the opportunity for participants to clarify if I've got it right in terms of those who are participating in certain aspects. So that's what I propose there. I would seek agreement, though, that I set a couple of deadlines within that we work. I think the applicant has got a copy of the foundation documents. That's essentially all the application documents and all the core documents that would normally be referred to. So probably a month from the note of the meeting, we would ask that set of foundation documents is completed and aligned on under that, and the applicant to coordinate that and work with our case officer. Does that seem reasonable, Mr. Trinick?
Yes, sure it does.
And hopefully we would be able to conclude all the supporting documents that are to form part of the oral sessions. That's the inquiry reports and any other reports that are referred to in hearing statements or such like, hopefully a month in advance of the oral sessions. Does that sound reasonable for everyone, that all their documentation would be prepared a month in advance? Mr. Finlay, I'll come to Mr. Trinick. Mr.
Trinick? I'd asked for the documents in addition to the foundation documents on which witnesses will rely to be available a little earlier than a month before, on the assumption that inquiry reports and hearing statements will be submitted a month before, because having access to others' documents to provide to prepare your own evidence will be exceptionally helpful. We need to know the documents on which others want to rely in order to finalise the evidence.
Okay, I'll build that into the timetable, and a final line will be drawn, if you like, a month in advance, but we'll ask for all the supporting documents to be available in advance of that. But in terms of the list, in terms of administratively sealing the list and not allowing other documents on, happy that that's a month, but I'll put into the timetable, or at least what I can say in terms of the timetable, for all the supporting documents to be named and numbered and on the list in advance. Mr. Ford. I think you're on mute, Mr. Ford.
Apologies. Thank you, sir. You've listed unaccompanied site visits. The community would like to have an accompanied site visit, certainly to the site and possibly to the AIL. I wonder if that would be possible to accommodate that.
Before we discuss that, I'll bring in Mr. Finlay.
So it's just really on the timetable, and asking you to take into account that the AI won't be ready till the 15th of May, and that will have an impact on potentially all sessions that are going to be considered. And there's always an outside chance that parties may consider that AI is inadequate, in which case we could raise that at the time. But in terms of timetabling for reports and the like, ask you to bear in mind, without setting specific times, that following receipt of that information, other parties, landscape and visual witnesses, are going to have to review that, potentially go on site to review it before they can start producing their evidence. So I'm not suggesting specific dates, but because we're looking at October now, that shouldn't be a major issue. But when you're setting the timetable, can I ask you to bear that in mind?
What you're suggesting is to not front load the timetable with dates, but if you like to kind of have it focused on that end date, which I agree with in terms of other matters we've talked about in terms of statement agreements and such like. There will be enough to make progress on, I think, but in terms of the oral processes, I think what you're saying is to leave as much time as possible between now and having to prepare the documentation in advance of the oral sessions.
Absolutely, sir.
Yeah. Okay. Yeah. Does that seem reasonable, Mr. Trinick?
Yes.
And the point about site inspection, to go up to the site, I'd be happy to leave that to the inquiry, and that if at the conclusion of the inquiry everyone's agreed to go to the site, then the reporter, would be happy to do that. May well be something that could actually just be agreed after the inquiry. But have any of the parties got any particular view on that? Has the applicant got a view that they would request it now?
No particular view at this stage. If it appears appropriate for them to be an accompanied visit to the site and to other places which emerge during the course of the oral sessions of the inquiry, then fine. But I don't think we know at this stage.
Ms. Shaw, you have your hand up.
Yeah, I just would like to say that the route is very important to us, and we would like to accompany, very important for us that we accompany anybody on a visit to the route, particularly.
So if I may just come in, I think it's important that you make clear, and I hope I'm not teaching grandmothers, that a site visit is not the opportunity to give evidence.
I'm sure Ms. Stewart is aware of that, but just in case you aren't, the site visit is essentially an opportunity for the reporter to be on site and to be pointed out matters of interest, physical characteristics, and things that they need to see. It's not an opportunity for debate and discussion, that would happen either through further written submissions or oral sessions. But I've certainly heard what you're saying, Ms. Stewart, and I'll give that some consideration. Mr. Collins,
it is particularly to point out certain features of the route, not to make comment, but to point them out.
Thank you for that. Mr. Collins.
I would have thought it was quite important to have a look at the route and the site early on, because it's one of these pictures worth 1,000 words type of things. If you actually see the landscape and what's there, I think it would give you a better impression of what people are talking about.
Thank you, Mr. Collins. I think I maybe wasn't clear earlier on, or maybe just alluded to it, that in advance of even setting out some of the further written submissions, I would anticipate that a reporter would visit the site even before writing out and asking questions. That's not to say that they wouldn't carry out another site and visit that would be accompanied perhaps to do with matters that we've discussed, but a reporter would generally visit the site reasonably early, often before a meeting like this, actually, but certainly before we would start writing out and asking questions, we would visit the site and make sure we appreciate what the interested parties are talking about on the ground. So thank you for that, Mr. Collins. Ms. Stewart, you still got your hand up. Is that an accidental hand, or did you have an additional comment? The hand disappeared. Thank you for that. So we've discussed that matter. There's been no request for a site inspection with regard to the historic environment. I think a reporter will be able to carry that out themselves, and probably in advance of a hearing on the matter. You will be aware that the contact officer for the case is Morven Campbell. I would ask that you contact Morven about the case, but I would encourage you to be mindful that all our case officers are dealing with an awful lot of work at the moment. So really contact Morven when you have to. Hopefully you'll be able to get other information on our website, and you should be able to see all the case documentation on the website. So our case officers are dealing with a lot at the moment, and Morven may not be able to respond instantly to your requests. So I would just flag that up. I will attempt to and hopefully send out the meeting note by next Friday. That's our aim, to send it within a week, and we hope to do that. And before I go on to any other relevant matters, Mr. Burnett, is there anything that you've heard from the council's point of view over the last 5 minutes or so that you had anything to contribute to?
No, sir. I assume the DPA will be in touch about potential venues if it's going to be in person, and we can start thinking about that. But everything else seems sort of fairly standard.
That would be the general approach. Morven would be in contact with the council, unless there is a particular preference from the community. If there's a community hall nearby or such like that they would want to let us know about just now, then I'm quite happy to hear that, and we can put that into the mix. But generally speaking, we would approach the council. Are you happy that we just do that, and the council would maybe advise on the best location locally? That's great, thank you, and thanks for that, Mr. Burnett, in terms of the venue. 13, any other relevant matters? I've laboured the point that I was going to make about the DPA and its resources, but please bear that in mind. It is highly likely that another reporter will be appointed, and likely to be after the note of the meeting, and essentially before the procedures get underway. That should not have any impact in terms of the procedures that we've agreed, and will be set out in the note of the meeting. But just in case you see another face in front of you, then it's with regard to the DPA trying to use its resources as best as possible. And if another reporter is appointed, then that reporter is likely to be there till the end of the process and has got capacity to do that. And now that we know the proposed date of October, what we will do is try to resource that to ensure that we would have a reporter either jointly appointed or separately and newly appointed to the case in order to take all the procedures through and to writing a report to ministers. I know that's unusual, but that's the situation we're in, and I'm afraid we've had to use our resources in such a way to get moving with a few cases to get them to this meeting, and it may well be that another reporter is appointed. Have you got any questions on that matter, or have I gone on about that enough? Okay, everyone's happy with that. Thank you very much. So just keep an eye out for what's in the note of the meeting, particularly the point that I made about clarifying who's to be involved in matters. And with that, just thank you very much for your time today. Thanks for everyone's contributions. It's been valuable. Hopefully I will make sense of all our discussions and wrap it up into the note of the meeting, which will be a few pages long. But please take time to read through it, because in a sense, it sets off the direction of travel for the inquiry process. So unless anyone's got anything else to say, I think we could probably all sign off. Okay. Thank you very much for your time. Thank you. And thank you to